The best lawyers aren't found in the big law firms. They're found in the stories of those who left. Hello, listeners and viewers, if you're on YouTube. Welcome to the Self-Employed Lawyers League. I'm very excited today because we've got, I can call him my number one client, no offense to everyone else, but Dicky was literally the first person who signed up to the Self-Employed Lawyers League. So I can say he is number one. But today we're going to learn a bit more about Dicky and how he became a lawyer and what he's doing really uniquely. I think it's quite exciting how he's approaching delivering legal services, and we're going to get into all that. But Dicky, welcome to the podcast.
Thank you, Jason. Pleasure to be here.
All right, the first question everyone gets started off with is, when did you become a lawyer, or when did you decide to become a lawyer, and what made you choose that degree?
So my path to becoming a lawyer is probably a bit different to the standard student or lawyer. I finished high school in 2007. I did not want to do law. In fact, I didn't even consider law at that time. My old man's an engineer, so I thought I'd go into engineering. Always favored the sciences over the arts. So spent 2008, 2009 doing engineering. Failed miserably. Emphatic fails. And at that point, my old man told me, maybe take some time off. Mm-hmm. Let's reassess. So between 2010 and 2012, I worked. Casual jobs, things like, a stock taker at Good Guys Warehouse, warehousing stuff, unloading containers, that sort of stuff.
Yeah.
And then in 2012, I decided, all right, I want to go back to uni, but I don't want to do law. Sorry, I don't want to do engineering because I know I suck at it. What's left? I really didn't want to do medicine or anything of that sort, or anything in the health industry, because I just do not, I don't like needles. I don't like blood. So it's not really my cup of tea. Mm-hmm. And then, well, what was left was law. So I thought, I'll give law a crack. So applied to do law, got into Murdoch University in WA. Mm-hmm. Thought I'd just give it a crack and see how it goes. It was quite frankly, just, I didn't expect to be here. I literally thought, all right, after 6 months, I might transfer to something else, but I'll give it a crack. So started law in June 2012 or July 2012, mid-semester. And that first semester, did all the stuff that I did at uni previously, put a little bit of effort in, but got really good grades. Mm-hmm. So I thought, okay, what will happen if I give it a real red-hot crack and see how it goes? So the next semester, I knuckled down and I said to myself, all right, I'm going to give it a real crack here and see how it goes. And got really good grades again. And then from that point onwards, I haven't looked back. Kept going. So graduated in 2016 from Murdoch University, and then got a grad role in Melbourne. So I moved to Melbourne from WA. I'm originally from WA. Yep. And then spent the next, 7 years in Melbourne, and now I'm back in WA practicing.
Yeah. And so that coming out of law school, how did you find the transition to getting that grad role, and B, was the first year as a actual lawyer, how different was it to what the theoretical study and stuff was like?
The transition was tough because I didn't really have an office job to begin with, so yep. I never really worked in an office job apart from the clerkship. So at that point, my experience working in an office was limited. So going from uni to an office role and learning the ins and outs of, just office nuances, just professional etiquette, professional communication, that didn't come naturally to me. I still remember when I was clerking at a law firm in WA, and just for context, the jobs I previously had were, like I said, in warehousing, hands-on stuff. I'd never really worked in an office. So my first clerking role, I was clerking at a law firm called Spurling Legal, and they did a lot of migration, criminal, and military law. Alistair Putt, he was a Navy lawyer, but he also had his own law practice. And I remember he told me to review a file and tell me give me your views. What do you think? So at that point, I had sent maybe 2 or 3 emails professionally.
Yep.
So I looked at the file.
Oh, wow.
I looked at that file and I said, right, okay. I said, and to Alistair, the
Mm.
partner, I said, hey, mate, I've had a look. I reckon it's this, this, and this. Keen to have a chat when you get the chance. And then he called me into his office and he said, look, what you said is fine, but maybe you need to learn how to communicate a bit better in an office context. So instead of saying, hi, mate, maybe say, dear Alistair, or hi Alistair, I've reviewed and considered the file.
Yep.
Please see attached or please see below my recommendations. So that was my first real exposure to communicating in a professional sense.
Yep.
And that was in a clerkship. So I only really had about 4 weeks with Alistair, and then I went back to finishing uni. So transitioning to that grad role, what I found really difficult was the soft skills that come with being a lawyer. I knew how to do the law. It's just communicating the way I did, the file management aspects, all the soft skills that you need as part of a lawyer. I found that transition difficult to begin with, but I had a great mentor, and he was very patient with me. So he taught me the ins and outs. And after 6 months, I settled in. But that first 6 months was challenging.
Yep. And so what's the difference? Because I'm thinking just in hearing the story you've relayed, because obviously the engineering side, you were like, no, absolutely not going to do that. What made you persevere in law to go, no, it's worth learning those ironically hard soft skills? What made you persevere? Was it that having that mentor or?
Yeah, so having that mentor really assisted, because I never felt like I was failing. I just thought, this is I'm learning. That's all it
Mm,
is, and it will come. I always had faith that it will come, and so that I always had faith that my mentor had faith in me. So that
yep.
really helped. And it was just about just learning and making sure that I'll get on top of it. And I sort of relied on my past experience at law school. I said, look, if I stick with it, and things will come good. Yeah,
Yep.
it's challenging at the moment. And when I was at law school, there were a couple of units I found challenging, and I knew if I stick with it, it will come good. And I applied that same principle. I looked at myself and said, look, it's just another challenge. Soft skills are as important as as the skills you pick up at uni in terms of in your degree. So sticking with it, trusting your process, and having a really good mentor did assist a lot.
Yep. Yeah, great. And so your first few years, would you say they were enjoyable? Did you have any horror stories, horror experiences? Was it all pretty steady for you? And did you work at many different firms or mainly just one or two firms in
No,
your first few years?
no. So the first 2 years, so I spent my entire restricted practitioner phase in the same firm. So
Yep.
it was Hutchinson Legal, and I practiced there for 2 years. No real horror stories. Every lawyer goes through traumatic experiences in their first 5 to 10 years, which you look back and go, right, okay, that was a learning experience. So you'll never do that again. So,
Yep.
there were those few days where, work piled up or something was urgent and I had to work through. But that was part and parcel of being law. Otherwise, no traumatic experiences at all, really. In fact, I would say it was probably one of the best experiences of my life because I met my wife there. So,
Ah,
right,
wonderful.
so she was the grad the following year, and I met her there. So without that place, I wouldn't be where I am.
So that, well, by definition, that's definitely would hint the experience in a very
That's
positive
right.
manner.
That's
So
right. So
from there, so because you said you were in Victoria at this time, and then
yes.
the next few years.
So then I moved to a firm called Goldsmiths Lawyers, a
Hmm.
boutique commercial litigation firm in West Melbourne, run by two brothers, Gary and Darren Goldsmith. When I got there, Darren was on the brink of retirement, so I still worked with Darren in the commercial team occasionally, but I was based in the commercial litigation team with Gary. And Gary had been practicing for over 40 odd years. So he was a fantastic mentor. Everything
Yeah.
I learned about commercial litigation, I've learned from Gary. Uh, he was for his demographic, he was incredibly patient and he was incredibly modern. So he knew how to litigate. He knew his skill set as well. He knew his strengths. His strengths were negotiating and getting the deal done as opposed to the nuances of the law. He
Yep.
was not an academic, but he certainly knew how to litigate. And that's where I picked up everything I know from litigation.
Yep.
it was a fantastic experience. And we at Goldsmiths Lawyers, or well, Gary at Goldsmiths Lawyers now, we specialized in sort of a value-driven practice. So we specialized in having running complex commercial disputes in a very lean environment. So we often had claims, or we were often defending claims against top-tier firms, and we had myself, Gary, and barristers that we briefed, and it was a very tight-knit, very efficient team. But we were able to get some excellent results at probably a fraction of the price that it might cost the client at a medium-sized firm or a top-tier firm.
Yep. Yeah, amazing. And then, so at what point in your career did the inkling of maybe I want to hang my own shingle and put myself out there? When did that start to occur?
So,
And then how long did it take you to make the leap?
look, it took a while because I'm someone who plans everything to the T.
Hmm.
So we were in Victoria. We got married in 2022. Me and my wife, who I met at Hutchinson Legal, and then we decided, we wanted to have kids, but then we also wanted to raise kids in WA. I wanted them to
Yep.
have the same lifestyle I had, or I enjoyed. In Victoria, in order to do that, we would have probably had to outlay probably, 2 or 3 million in funds for a new house near the city, because we were both working in the city, so we didn't want to commute for an hour or so and lose that
Yeah.
in the day. So we always wanted to be close to the city. We wanted to be close to the beach. We wanted to be, we wanted our, things to be accessible. So looking at all of that, we wanted a big property with a pool. Looking at all of that, in Victoria, it would have taken us probably another 5 or 6 years to get there.
Yep.
Whereas in WA, we were able to buy a house in 2022.
Yep.
And then we rented it out. So the plan was to move to WA once we had children, or
Mhm.
once we had a baby boy. And so when Maxie was born in 2023, we decided to make the move. Now, we always talked about, so once we moved to WA, we would probably look to set up my own practice.
Mhm.
It wasn't anything serious. It was just there in the background. And then once we got to WA, I moved to another firm, and I realized that, look, I probably think there's a better way to do it, but I'm not going to get that opportunity to implement that unless I make partner at a law firm,
Yep.
or something along those lines. I'm also very risk averse, because making partner at a law firm means that you're going to have to put in capital to buy in. And often that capital you're going to have to borrow from the bank. You're going to have to live for a year on essentially a loan and hope that, at the end of that year, you've made enough money, or you've made enough profit. And so, there's a lot of things you're assuming there. You're also putting a lot of emphasis and a lot of reliance on someone else to get you there. I looked at it myself and I said, look, I'd much rather back myself.
Yep.
I don't need to borrow any funds at the moment. I can commit from my savings. And because I'm starting my own firm, I can implement the practice, or I can practice the way I want to practice. And I don't have to wait 5 or 10 years to make partner. So in 2023, things started getting serious. Once we moved over to WA in 2024, we had the plan that we were probably going to start it in 2025, sometime in 2025.
Yep. That's probably, I'm thinking we probably first met late 2024, I reckon. Then we had another chat earlier
That's
this
right.
year, and then
That's right. So
I was very excited. Yeah.
it's all very, as I said, I plan everything to the T. So we
Yep.
always, nothing is set in stone, but there's always a plan, and there's always a backup plan and things. I'm very risk averse that way. So
Yeah.
We always had it in the back of my mind back of our minds that, I want to set up my own practice, just because I want to practice the way I want to practice, and
Yeah.
we'll get into that a bit later. But and just the opportunity to do that wasn't going to come if I was working at a mid-tier or top tier firm until I made partner. And even then, it would have been limited because I'm working with other partners. I'm working within the constraints of that partnership or that structure. So it's not going to be a free reign for me. And I have to, the risk is humongous. I have to borrow funds, buy into the partnership, and hope to God that the partnership makes a profit. So there's a reliance on other people, and I wasn't willing to bet that. I wasn't willing to hedge my bets on that. I'd much rather back myself.
Yeah. Oh, which is a Fantastic attitude. And so, Spurling Legal, the name, because you didn't go with your name, where did Spurling Legal come from? That name?
Yeah, so that's that's it's a very interesting question. Spurling Legal came from our own lives. So our first house that we bought in Victoria was on Spurling Street in Maidstone. So it's a very important it's a bit of a sentimental thing,
Yeah.
but also that house is very important to us because it's the first house me and my wife bought together. We
Yep.
got married in that house. Our son Maxie was born, and then we went back to that house. So a lot of great memories on that street.
Yep.
Um, and then we considered whether having my name uh, as the name for the law firm seemed a bit traditional. And I'm not a traditional person. I wanted
Mm.
to take a modern approach and try and keep the firm as modern as possible. And that starts with the name. So
Yep.
I looked at it and went, look, I don't want to put my name there. I'd much rather try and keep it, put something that's important to me. And then we came up with Spurling.
It's a great way to do it too. And it also doesn't, because I know your plans in the long term are obviously to hopefully, and I think a lot of law firms and lawyers are going to embody how you're doing, how you're approaching law.
Yeah.
But then it's not just tied to any one single name or anything. And it also
Oh,
shows there's no, the show suits and everything, where the whole ego of the whole show is whose name's on the wall. That's basically what all the drama happens is whose name's where. You've
that's
sort
right.
of ensured
And
that won't be an issue.
That's right, Jason. And from a practical perspective, when it comes to valuing the firm or valuing the business, often if you have your name tied to it, that will impact the value. So if if and when the time comes and I'm looking to sell my business or put a succession plan in, I'll have to give the business value. And
Yep.
if the goodwill of the business is tied to my name, that will impact the value. So that
Yep.
was another consideration. That was the practical consideration that you always take into account when coming up with things like that.
Yep. And so, a topic I can't wait to hear you speak to. You've decided you're not going to strictly look at the 6 minute timer and make sure every time someone calls you, hit that timer. How
Yeah.
have you approached, in your opinion, value based slash? Because I know yours is a bit of a hybrid of value fixed, but importantly, it's going to give certainty to the business clients.
Yeah.
What's been your methodology approaching your how you're going to bill?
Yeah, look, that was something I spent a lot of time considering. One of the bugbears for clients in the legal industry is that often traditional billing doesn't really provide value. It's they find it quite jarring, and that was the feedback I got from a lot of clients that they don't want to pay the hourly rate. Quite frankly, that's quite in this day and age they don't understand why we're still billing at an hourly rate. Why can't we provide fixed fees? So I looked at fixed fees and I thought, okay, that still doesn't provide clients the value that they're seeking, because often when you do a fixed fee arrangement, you tend to overestimate to cover all contingencies.
Mhm.
And then the client will incur those fees no matter what. So you could do 10% of the work and the client still incurs those fees. And there's one line or two lines saying what it is. So I looked at maybe coming up with a hybrid. But then I had to work around the fact that if that's the case, we have to put time down in order to track that. My firm, I've made it. It's one of the policies that we won't have budgets or billables for any staff. It's not
Yep.
how I want my firm or myself to practice. I don't think having budgets and billables really fosters teamwork and
Yep.
cohesion. You're often fighting against your colleague for work, or you're competing against them, and that does not really foster teamwork. And at a firm like mine, teamwork is very important. So managing that was important. So I looked at technology. I looked at tech and how tech can assist there. So I've implemented a few systems in my practice or at Spurling Legal that greatly assist with that. So first and foremost, in terms of scoping out a cost proposal, I use a legal AI assistant. It's specifically designed for lawyers in Australia. It's not a run-of-the-mill chat GPT.
Mm.
So it's and I pay a subscription for that. It's about $300 odd, and it's a fantastic piece of kit. You can you can put in all the facts, all the instructions, and it will learn. So after I did a few proposals with it, it really understood how I want my proposals to come through. So it would look at the different facts that I put in or that I plug in, the instructions, the different documents, and it will come up with a proposal to say, it's up to me. I usually set the parameters. So I'll say, come up with a proposal or a cost estimate up until mediation, and it will come up with that. It would scope it out. It would come up with anticipated applications. And then it's about me going through and refining that and settling that and making sure. I still have to spend the time doing it, but it's nowhere near as much as I would have if I didn't have it. So relying on tech is very important at Spurling Legal. I also have other subscriptions where, it tracks my time automatically. So I don't need to actually plug in the time myself. It tracks my time automatically during the day, and at the end of the day, I can just go to the software and it can tell me, all right, I'll spend so-and-so hours, or half an hour, or 5 minutes, or 10 minutes working on this Word document, and it will automatically generate a narrative for time entry purposes. I just settle that and I look at it and I make sure it's accurate, and that's it. So having tech really does assist me in that regard. And without that sort of tech, it would have been hard to implement. But so far, it's been good. I've tested it out on a few different matters, and it's working really great. And I've got some really good feedback from clients in terms of how the costing model is working. I think it's a great approach. I think with the tech that I have, clients get a lot more certainty in the sense that the professional fees are capped. So I estimate it in stages, and each stage I cap the fees, so that way I wear a bit of the risk as well. So it's not just the clients wearing the risk, which is what they do in a traditional model. It's an hourly billing rate. They wear all the risk. Fixed fees, you tend to wear all the risks. In this particular scenario, both myself and the client wear the risk. I like to think equally. So if the costs of the matter exceed the stage, then I wear that cost. And the next time I will learn, and we will try and scope it out a bit better. But at the moment, it's been working really well.
And that's why I got so excited by it, because I could see, particularly in the field of commercial litigation, where it is always, and I remember when I was asking the partner, because I was the relationships manager, so I'm trying to sell the client to sign up with us, and the partner, most common phrase, how long's a piece of string? And I used to be like, you've been doing this 20 plus years. How can you not scope out the initial thing? And what I liked is, if we don't scope it out and take a little bit of risk and go, you know what, we'll stick to this, the client doesn't feel like we're sort of in the same rowboat paddling with them. They feel like, well, they don't care, because the lawyer's just going to go, well, I don't care if it gets rough seas and things happen, because I'm just going to charge you by the hour, and it just means I can keep the senior associates billing. Whereas I go, at some point, the clients are going to see through this. And then, as we've seen, the technology's now come that someone like you can come out of a traditional model and almost have a small army of lawyers, or support at least, at your disposal to then deliver litigation at a far more affordable rate.
You're almost like you correctly identified. Clients don't feel like you're buying into their matter in a traditional model. In this particular model, we're investing with the client just as much, as they're investing with us. And again, the tech assists us, but ultimately, I still have to spend the time scoping it out. The issue with scoping out proposals is it's not chargeable under the uniform law. So you're not allowed to charge for it. So firms and lawyers don't spend a lot of time doing it, because you're not able to bill off it. So it becomes difficult to spend 2 or 3 or 4 hours scoping it out, which is a bit bizarre, because if you look at other industries like construction, they always scope it out quite well, but the cost of scoping is inbuilt into the proposal. Unfortunately, you can't do that in law. So I had to come up with a better way, and it still takes time for me to scope out a proposal, but I'm happy to spend an hour, if that, scoping out a proposal and getting it right for the client. And that way, they get a bit of value out of it as well, and they understand what's happening, and they recognize that we're buying into them as well, as much as they're buying into us.
Yeah. Well, and even just that, because it allows, because ultimately the business owner just wants to go, it's almost a cost benefit analysis. Is it
Yeah.
worth fighting the 50 to $100,000
Yes.
knowing this can come out of it? But unless you have that, which you're going to give, and over time, that's what excites me is the AI will get smarter at predicting almost
Yeah.
what the scope will need to be, the contingencies. That's just
Yeah.
going to give them so much certainty of what's worth pursuing, or like you said the other day when we were chatting, when it's worth negotiating and just getting this settled before we actually step foot in the court. Let's
Yes.
get a
Yeah.
settlement in place.
What I'm hoping this model will provide is more buying power for the small medium enterprises, more negotiating power. We've come to a stage in law where the cost of pursuing litigation is just as important, or is just as is has just as much weight as the merits of the case itself. Because small medium enterprises nowadays, if they have $100,000 dispute, or $110,000 dispute, and you want to take it all the way to trial, there's every chance a lawyer will say, well, it's probably going to cost $110,000 to run it. It's better
Yep.
to settle. And of course, it's always better to settle because there's always risk, but the cost benefit analysis there doesn't really weigh in the client's favor. Often clients will say, well, what's the point of running this if I'm going to incur that much, even if there's great merit to the case.
Yeah.
Um, and you can't, and you face that it's sort of the negotiating table as well, because you'll come up against a firm with an army of lawyers potentially, and they will say, well, even if you run this, it will cost you this much. There's the real risk that you might lose. If you win, you're spending just as much money. So what's the point? And they'll try and push you into a corner so that you settle. Now,
Yep.
Spurling Legal is hoping to change that narrative. I'm hoping to give small and medium enterprises a bit more bargaining power at the negotiating table and say, look, yeah, the costs are going to be significant, but it's nowhere near as what it's going to be for if I was to engage, say, another law firm or a traditional law firm. So
Yep.
they have a bit more negotiating power at the table, and they don't have to worry about the cost of running the matter. They can look at purely the merits of the case and make a decision on that, and the cost can be in the background to a certain extent.
Yep.
At some point, they have to consider the costs, but it doesn't take front and center stage like it does nowadays.
Yeah. Oh, and that to me, and that's where I can see AI is going to, well, definitely change the industry, but it's going to make, and I love the way you're framing it, the merits of the case.
Yes.
People don't necessarily have to be as worried about pursuing justice, because I remember one thing which disheartened me to no end when I first entered the industry 3 or 4 years ago, and a partner said, people can't afford to pursue justice. They can't afford to pursue their principles. And I was like, that's pretty sad, because our entire justice system was set up to be able to even the scales, no matter for any man, whether it's the king or whether it's the peasant. And I go, if that's someone who's been in this industry 25 years and that's how they view it, I go, something's got to change. And then when I saw the AI coming in and particularly heard how you talked about it, I was like, oh, this is that great leveler to actually bring back the balance of scales, and the merits of the case will be what's most important, not the cost of pursuing it.
Yes, yes, it's you're quite right. It's got to a stage where at least in the commercial litigation context, it's quite expensive.
Yeah.
That's the nature of our justice system. It's quite expensive to run a claim nowadays. It always has been, but not to the extent it was now. And now you'll find, like I said, you're finding if you have $100,000 dispute and the quantum is $100,000, sometimes that's not enough, to run a
Yep.
claim. That's not enough. It's just, at least at the traditional firm, often you will say, okay, you'll get to a mediation. If you try and settle it, great. But if you can't settle it, there's a real risk that you might incur just as much. There's plenty of examples in recent memory or in recent history where the quantum of the cost of the case have exceeded the quantum by a substantial amount. I think one only has to look at the recent case about that reporter from the ABC that sued
Mm.
for, and she was successful. So unfair dismissal, I think, from memory. And she was successful. And I'd imagine the costs of running that claim were quite significant. Now, there's some solace in the fact that she might get some of it back. But
Mm.
again, there's a real risk. She took a real risk by running it all the way to trial. Not a lot of businesses can do that because they're a business, they're a startup,
Mm.
or even small medium enterprises. They'd much rather settle and look to continue with the business and survive. But I'm hoping Spurling Legal changes that narrative and say, look, there's a bit more negotiating power. Like I said,
Yep.
costs are not center stage, but they're still there. They're still at the forefront. You still need to consider it, but it's not going to take front and center.
Yeah. No, it's a wonderful goal. Now, my last question before I'll ask you how people can get in touch, but I'll also put it in the show notes. You've only been in the league a few days, but what have you thought, Self-Employed Lawyers League, and what are you hoping to achieve over the next 12 months?
Look, I think it's great. As a self-employed lawyer, what I was really nervous about was the fact that I don't have anyone to bounce ideas off. That's how I operated. At Goldsmiths Lawyers, I always bounced ideas off Gary. It
Hmm.
was me going to him, asking him questions on a daily basis, almost on an hourly basis, just going into his office and bouncing ideas off barristers and things like that. One of the one of the nuances of working as a self-employed lawyer is that you're often doing it solo. So in
Yep.
order to bounce ideas, that opportunity to do bounce ideas off a colleague is not readily available. So joining something like the Self-Employed Lawyers League seemed like a no-brainer for me because I can meet up with other self-employed lawyers, bounce ideas, refer work to other lawyers within the group because I'd imagine I'd get a few inquiries in different areas as my firm builds and as we progress through the year. So having those contacts and having that support network was important for me.
Yep.
And I think it will work like a full service firm essentially. You've got a group of lawyers. If it's not within your area, it gets referred to. It's the same thing that happened at Goldsmiths Lawyers. We got a lot of referrals from our commercial team to the commercial litigation team. And
Yep.
likewise, we referred matters to the commercial team as well. I'd imagine it's akin to working at a law firm. It's just that you're all working for yourself, but you've all banded in a group and relying on supporting each other.
Yeah. And that's why I was very excited. And honestly, I'm publicly, so everyone sees, very thankful that you joined a community where you were literally the only person in it for a few days, but we've got people coming in now and it's exciting to see. So
Yeah, look, as I said, look, I plan everything to the T. I look at the long-term objectives. It's not,
yep.
I'm not looking at the instantaneous result. I'm not looking at instantaneous results or results in the short term. I'm looking at
Yeah.
what this can grow into and what this can be in a year or 2 or 3 years.
Yep.
And to be a founding member or even just one of the initial members is great because I get to so be part of something along with you.
Yep. And that's what
yeah, sorry.
No, go on.
I've just made it a point in my. I was just going to say I've made it a point in my practice, or at least in Spurling Legal's practice, to engage with other new businesses to try and work with them because, as I said, I'm a new business, and they will be facing the same hurdles as I do. So there's a bit of community there, or I'm expecting a bit of community there as well.
It's camaraderie. It is, and it's camaraderie to go and that's why I've started doing. I'm going to do a weekly blog inside the league about here's what I went through. Like in my head, as a brand new business, like we're still a new business. I have started businesses before, but we're still a new business, and so this is what I'm going through, and hopefully. I think it's just sometimes you need to know other people are going through these thoughts in their head and these sort of concerns and anxieties and stuff.
That's right. And even having just you to bounce ideas off over the last week has been immensely helpful. So that's just and that in itself has helped me in my practice already. So once you get more members and once you have more people joining up and more people attending the weekly conferences, I'm sure it will be a very helpful forum for other self-employed lawyers as well.
Yeah. Well, before we tune out, what's the best way for someone to get in touch? And also, have you got who's the ideal client? I know it's the SME business owners.
Yes.
Who are you looking for?
Look, small, medium enterprises who are facing commercial disputes. So whether that's debt recovery or something more serious like insolvency or restructuring. Small to medium enterprises. That doesn't mean I don't act for large enterprises either. I do. That's not an issue. In terms of ideal clients and ideal referrers, probably just accountants. A lot of accountants and financial planners deal with these sort of small to medium enterprises, and if they're looking for a lawyer that can provide some value and doing something a bit different, then yeah, I'd encourage them to get in touch with us. You can always just go to the website and our contact details are there. Or otherwise, you can contact me on my work mobile, which is also available on the website.
Fantastic. Well, like I said, thanks very much, Dicky, for A, being the first member, and B, being the first podcast guest. So I'm sure we'll get you back on in the future because there'll be plenty to discuss commercial litigation, and I love talking business. So I'm sure we'll have you on in the future.
No dramas, Jason. Always a pleasure.